Chair recognizes the gentlelady from Hawaii, Ms. Hanbuso.
Thank you, Mr. Chair. Professor Leshy, in reading your testimony, you basically said that you've dealt with the Endangered Species Act, which was, of course, passed in 1973 in various settings, and you make a reference to the fact that you also did it in government service. Can you tell me what kind of government service and for how long you were doing that?
I worked in the Carter administration, that will date me, for almost the entire time, and I was in the Clinton administration from day one to the last day.
And what role did you play in terms of working with endangered?
In the Carter administration, I think my title was Associate Solicitor of the Interior Department for Energy and Resources, and in the Clinton administration, I was the solicitor. That's the fancy word for the head legal officer.
So I see why you said that you probably are more than qualified to testify about this. One of your, you spent a good deal of time in your testimony talking about the Edwards Aquifer in Texas, and it brings to mind something regarding state law as well as Endangered Species Act. And first of all, I assume from the testimony, from your written testimony, that there's nothing considered like some kind of riparian water rights in Texas law that would give landowners downstream or someone else the right to actually use the water source. Am I correct in that?
Well, yes. The issue in Edwards was the Texas law as it applies to groundwater, water underneath the ground. And Texas basically had and still has outside the Edwards Aquifer, I think, no law. I mean, the law is anybody can stick a straw down, drill a well, and pump out as much water as they want for any purpose. And the kind of cruel irony here is that Texas law actually tells landowners that they have property rights in the water underneath their land, but they have no right to keep anybody else from sucking that water out from under them. So it's not really a property right at all. It's called the capture doctrine. And it basically means that there is absolutely no thought to managing this water source for the future. And what happened at Edwards was because of this quirk that there were endangered species threatened by it, Texas had to start managing the Edwards Aquifer to look to the long term, to sustain it over the long term. And all those jobs and all that economic activity and all those people, millions of people living over the Edwards Aquifer depending upon it. So the Endangered Species Act resulted in a huge improvement. And I think most people who understand this in Texas would actually agree with that.
So I guess the other part of my question would be that in a situation like that, if you didn't have the Endangered Species Act and the intervention of the feds, that in essence you could have no aquifer left today?
Absolutely. I mean, this was a race to the bottom of the aquifer. That was what Texas was engaging in, and it was presumably going to, dry up the aquifer before anything had happened had the Endangered Species Act not been there.
Do you have any other examples? I know that you pointed out that the Texas situation, so in the time from the Carter administration, the Clinton administration, and the role as a solicitor, were there any other examples of actual intervention on a state level to ensure the preservation of an aquifer or water source?
Well, sure. I mean, there are a lot of rivers, for example, in the West that are being managed in part to protect endangered species. Almost all of these rivers are basically regulated, controlled by dams, usually federal dams. And the Endangered Species Act is affecting how those reservoirs are operated. I think, and in many cases, and I've referenced this already, there have been major successful efforts at these multi-species habitat conservation plans that apply to these river systems that have resulted in protecting the water supply for people, but also protecting the species. They've been quite a success story, and they have involved intensive cooperation between state water authorities and federal agencies. I mean, this is not a top-down federal exercise. This is really a cooperative exercise. And I think if you ask most water managers in the West, are we managing water better because the Endangered Species Act is there? I think most of them would say yes.
So, being a devil's advocate, would you say that one of the concerns that people who are adverse to the Endangered Species Act is the fact that you could use that act and actually step in and control, for example, a state's water system?
Well, you know, the net effect at Edwards was the federal law told the state you had to do something about managing this. The mechanics of what they did, and that system is a state law system. It was passed by the Texas legislature. It's reviewed by the Texas courts. I mean, so the federal government sort of, and the Endangered Species Act sort of provides the club, but the mechanics and the decisions about how the management is going to take place was entirely state.
Thank you. Thank you, Mr. Chair.
Chair recognizes the gentlelady from Hawaii, Ms. Hanabusa.
Thank you, Mr. Chair. Thank you both for being here. In Administrator Schwab's position statement, he says that the NMFSS and the U.S. Fish and Wildlife Services are to list species and to determined to be endangered or threatened, and to subsequently protect those species and their habitats, and that's a mandate for both of your departments. Now, in that light, when I reviewed Director Ashe's statement, Director Ashe, you talk about habitat conservation plans under the ESA, and then you also mention ESA conservation action plans with the Bureau of Land Management and various other parts of the department. I'm just curious as to whether these are specific terms of arts and they refer to different kinds of conservation plans.
Excuse me. A habitat conservation plan is a specific is a statutory term of art. So in Section 10 of the law, where we are authorized to issue permits for incidental take associated with otherwise lawful activity. So if you were a private party and were undertaking an activity that was otherwise lawful and would take endangered species, we can authorize you to do that. But if you develop a habitat conservation plan to minimize the effects of that take. And a candidate conservation agreement is an administratively created instrument that allows us to work with a federal agency or another party to promote conservation of a candidate species before it gets on the list. So it's a way that we try to get ahead of the curve and try to deal with species conservation issues early.
So when we hear the words an endangered habitat area, is that different from the habitat conservation plan? When there's a designated endangered habitat, in other words.
Critical habitat.
Critical habitat, right.
Critical habitat is another function of the law. When we list a species, the law asks us to identify the critical habitat for that species. And generally, the law commands us to do that. There are some cases in which we can decline if we determine it's not prudent to determine critical habitat, but in general the law asks us to define critical habitat. Critical habitat is not a protected area. It doesn't set up a refuge or a reserve of any kind. It simply is an indication of what are the physical attributes of habitat that are important for the survival and recovery of the species. And there are restrictions against federal agencies for adversely modifying or destroying critical habitat. So it doesn't apply to private landowners unless they are applying to the federal government for some form of assistance or authorization. So
in Administrator Schwab's statement, he talks about the ESA and 16 U.S.C. 1531 to 1543 that requires the list and then their habitat. So that's what you're talking about now, the endangered habitat. So back to, the critical habitat. So now we have critical habitats, which do not really, are just a designation. And then we have habitat conservation plans. And there's this ESA conservation action plans that you also referenced. So out of all of those, which is the most restricted or restrictive plan that one could be subjected to?
I don't think it's, I mean, they're all actually, habitat conservation plan is a permissive plan. So when you develop a habitat conservation plan, it allows you to take, to do something that's otherwise unlawful, to take an endangered species. So it's not a restrictive plan, it's a permissive plan. A critical habitat is not a plan at all. It's simply a factual identification of habitat that is critical to the survival and recovery of the species. So it's not a plan, it's an identification. A candidate conservation agreement, I would say again, is not a plan, it's an agreement between two parties, the U.S. Fish and Wildlife Service and the Bureau of Land Management, or the U.S. Fish and Wildlife Service and a private landowner. And so those are voluntary agreements.
Thank you, Mr. Chair. My time's up, but could I request that they sort of give us a chart that I can easily follow?
Absolutely. I think that would be very, very helpful, and I'd ask you to provide that again for the full committee, and we'll certainly see that you all get that. That's a good suggestion.